This is case 2023-0030, State of New Hampshire versus Derrick T. Moyer.
Good morning, Gordon. I understand you reserve 2 minutes.
May it please the court, I'm Joshua Gordon. I represent Derrick Moyer, who is here this morning, and I reserve 2 minutes. Recklessness is consciously disregarding a substantial risk, and disregarding a risk means a gross deviation from what a law-abiding citizen would do. Derrick Moyer acted responsibly, well within the contours of a law-abiding person. While there may always be additional precautions one can take, Mr. Moyer took substantial and reasonable precautions to avoid the risk of harm. He was shooting into a 40-foot berm, which 40 feet is like a 4-story building. He used an anti-ricochet device. He shot from a spot 2,000 to 3,000 feet from the nearest dwelling in that direction. He was shooting in the daytime. The area between his range and Gabriel Court, where the bullet landed, was heavily forested. Mr. Moyer was aware of his gun's tendency to rise and knew not to shoot in the air. And he even took the precaution of a mid-range rifle. And the SKS, so that's not in evidence, is normally not effective beyond 300 or 400 yards. And the distance here is twice or even 3 times that. And you can see from the photos that are in evidence that by the time the bullet got to Gabriel Court, it didn't have enough force to even break the second pane of glass. Recklessness was McCabe, who fired a handgun in an apartment building with children sleeping a few feet away, or Farrell, who fired a gun to his friend's face, or Haynes, who brandished a loaded gun in downtown Manchester, Elm Street, or Wilson, who fired a gun in a crowded house party. Those were reckless. That Mr. Moyer missed his target does not make it reckless. It makes it an unfortunate accident.
Can we make an inference based on the trajectory that it was shot into the air? Shot up?
It obviously went above the berm, but it wasn't shot in the air. It went above the berm, and that is an obvious inference that can be drawn, of course.
Well, it went above the berm and it went above the forest as well.
That's right. It went over the forest, and the Gabriel Court is roughly the same elevation as where he was shooting from, so it's hard to know.
What did you mean when you said it's not effective beyond 300 or 400 yards?
Well, that is not in the record, but generally this gun is not effective beyond 300 or 400 yards. By the time it gets there, it doesn't have the force to do much. And this distance was much, much greater than that. The gross deviations from a law-abiding citizen, which this was not, was Lamprey, who did swerves with kids in the back seat, in the back of her pickup truck when the children were unrestrained, or Hull, who clipped a cop with his mirror because he was too impatient to wait for a break in traffic, or Belleville, who continued texting after he nearly hit another car.
But your client knew that the SKS had a tendency to rise when he fired it, correct?
He did, and that knowledge was one of the things he took into account when he was firing that gun.
How? I mean, what would be an appropriate precaution for a weapon he knew that would have a tendency to
try
rise?
to control it, I think. Mr. Moyer's conduct, in contrast to the gross deviation cases, was not any deviation at all. The safety precautions he took, the berm, the anti-ricochet device, the distance, were those that a law-abiding person normally does.
And this may or may not, but if the place from which he shot the gun was the same elevation as the apartments, 2,000-3,000 feet away, this 40-foot berm then is in a pit kind of arrangement?
No, it's I went and saw it.
It's higher than...
It's higher than...
Than elevation from which the gun was shot?
Yes.
So there's the berm, and then here he is, and here are the apartments way over here.
Yes, it was like a lot of these. In my town, I see target shooters use an excavator, push up a berm, and shoot into the berm.
Yep.
To move on, Mr. Moyer was not sentenced to 5 years, as the state says in his brief. He got 30 days in jail with 11 months suspended. Finally, that Derrick took the shot, that Mr. Moyer took the shot, was not proved beyond a reasonable doubt. His son testified that he didn't know who was shooting that rifle, on the Sunday in question. It could have been him, he testified, or it could have been his father. That makes it impossible to distinguish who was holding the gun when that particular bullet was fired. And because there's no direct evidence that it was Derrick Moyer, the state has to disprove the reasonable alternative, which it did not do, and accordingly, this court should reverse.
I have in my notes here, and maybe they're wrong, that Allen denied shooting on Sunday. Is that wrong?
I think he said he didn't know whether, he said he was shooting on Sunday, he denied shooting that gun, but then he said, when asked directly on cross whether he was shooting the gun, he said, I don't know. Was your father shooting the gun? I don't know. So I think, I don't know, there's no direct testimony that puts the gun in Derrick Moyer's hands. And that's
Except that he testified that he had been shooting that gun over the weekend.
Derrick Moyer never testified. The son testified, excuse me.
Right, the son testified.
That were shooting that gun over the weekend.
Yeah.
Including that day.
Including that, well, no, he said, I don't know to that day. There's no further questions?
Actually, I have a question. Did you have an argument in terms of the proof of the risk of serious bodily injury to the two juveniles as alleged in the indictment?
That's not an issue in this case, and it wasn't raised or preserved. I think it's an assumption that there could have been bodily injury. Of course, there was not, however, but the law of recklessness does not take injury into account.
But why isn't it a conscious disregard of a substantial and unjustifiable risk to shoot the SKS with a known tendency to rise? And it did rise, and it did go above the berm, and it did go above the trees, and it did go into someone's home. Why isn't that?
Well, that happens, but the question is whether it was reckless. And the precautions he took to address, he knew it was a safety risk, and took the precautions to avoid that risk.
But what were, of the precautions you've identified, what are the ones that are specific to the SKS and its tendency to rise, as opposed to any normal precaution for a gun that didn't have that tendency?
Nothing in the record, Your Honor. Thank you.
Attorney Baldridge. Thank you. Attorney Gordon.
Thank you. I want to address Judge Contaway's question about Shepard. Shepard drove over the yellow line, and that was not reckless. And contrast that with Bellevue, who drove over the yellow line while he was texting and didn't look up after he hit one car, then hit the other car. And that's the difference between reckless and not reckless. What Bellevue didn't do was look up after something happened. He didn't take the reasonable precautions that a law-abiding person would do. That's the distinction here. This is like Shepard. You make a mistake, and that's what happens. The second issue I want to address is the immunity letter that the son got is in the record. It's in the appendix. It doesn't say much about why why the younger Mr. Moyer had Fifth Amendment problems, but I think that's relatively apparent that he was there and could have been the one holding the gun as well. Thirdly, the layout of this land is, once upon a time, it's apparent when you stand there, and there was a view, that this was once very rural, and Mr. Moyer's land, there's now suburban development on this side and this side, but there's nothing a long way that way. And so when he shoots, and he shoots all the time, engenders a lot of complaints from the neighbors on this side and over on this side. There's a whole row of houses here and a whole row of houses here, and that's why there are complaints. But he doesn't shoot that direction. He shoots the berm is that direction, and he shoots, and then that's essentially where the bullet went. Thank you very much.
Case is submitted. Court's in recess.